Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
And that was your last.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip. Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumbs.
And honestly, Megan, if you don't like it, I'm sorry.
She's the devil.
Megan Fox. Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy shit.
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's.
You pissed off the wrong woman.
Oh my God! I have been assaulted, but Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan Fox. Thank you. Cheers.
Welcome back, everybody, to my channel. It's me, Megan Fox. I'm back from Florida. It was like a bazillion degrees, and it's also a bazillion degrees in my office. So pay no attention to Pamela Fanderson over here. I have to have the air conditioning going. I know it sounds like we're in a warehouse or something, but what are you going to do? I had to jump on today. I wasn't going to, but then the Karen Reed news broke, and it is unbelievable. And here to break it with me is Brad, IT Goatee. Brad, how you doing?
Good. How are you?
I see that you have a fresh haircut. Summertime is here. Look at you looking all marine-ish, military.
Well, this is my standard cut, and then as soon as it grows out and I feel like I'm sweating in my bed, I'm just like, nope, it's going.
All right. Well, the only reason why I was late today, I see some of you were giving me grief about being late. Well, I was only 5 minutes late, and the reason is I sat down, turned on my camera, and realized I couldn't find my camera. I was like, where the hell is the camera? Oh, yeah, I took my tripod to Florida. So I had to go dig through my bag, which I still haven't unpacked, and find it and reset it up. So sorry about that. All right.
Whoops.
Larry Forman, DUI Guy Plus, is going to be dropping in here when he can. He is live with the Rust trial right now, and Chandler is in the courtroom there in New Mexico. So that's pretty interesting. I want Larry's, reaction to this, because this Karen Reed thing is unfreaking believable. Now, I didn't cover the Karen Reed trial, but I watched it, and I actually watched everybody's recaps multiple times. So I watched Ian Runkle, I watched Legal Vices, I watched Larry, DUI Guy, and this case was unbelievable. Karen Reed was clearly not guilty, clearly not guilty. And so when it ended in a mistrial, I mean, everybody lied. all of the prosecution's witnesses lied. In fact, right before this news broke, Brad, I was working on, I'm going to do a stream about this ridiculous new court TV panel that they just did, saying, oh, I wish we had all this evidence. And the evidence they said they wish they had was evidence that was fucking presented at trial, Brad.
Mm-hmm.
It was literally presented at trial. The guy from Court TV, that idiot, I don't know his name, but God, he's so dumb. He's like, if only we could have had the phone records from all those people in the house so we knew what their movements were and who they were texting. And I was like, dude, were you watching the same trial? They all blamed it on butt dialing.
Yeah,
hello.
It was silly because I didn't watch the Karen Read trial as in deeply as thoroughly as you did, but even I knew that evidence was there. Like,
and he's literally doing this panel like, oh, it would have been so much different if we had seen there was a flurry of activity between these people. And I'm like, do you not know about the 2 a.m. butt dials? Do you not know there were 7 calls to John O'Keefe's phone? Clearly, like she was looking for the phone. Oh, come on. I can't. So I am going to go over that probably later. But then as I was doing that, and yeah, they destroyed their phones. One of them threw out the phone on a military base in one dumpster and then drove to another dumpster to throw out the destroyed SIM card. Like, you got to be freaking kidding me that this all happened. By the way, folks, your tips are not only appreciated,
mandatory.
But mandatory at this point. Okay.
The mouse has taken the money.
The mouse has taken all the money. All the money. And if my children are going to have a decent rest of their summer, although I should just tell them, suck it up and stay in your room because, you know, you got like, 10 days we were gone. It was insane. Also, we bought, I'm going to have to, wait, let me edit this. Let's see. Mouse.
Tell them kids they need to start setting up lemonade stands because.
Yeah, tips to combat mouse ARPing. At Disney. Okay, so you know what we did? My husband is so crazy. He set up a surprise for them. And when we went to Hollywood Studios, they each were allowed to build a droid. I should have had it on my desk. Oh my God. Should I go get it? Should I go get one of the droids? All right, hold on. I'll be right back. Hold on.
All right. Legal Vices says, I feel smart with Jackson and Yannetti agreeing with my legal analysis. That's pretty cool. I'll have to catch up with some of that. So yeah, you got rough stuff going on in New Mexico. You've got Karen Read. I think I've seen that document at least 12 times being posted on the internet by different people.
Do you know, by the way, about these droids?
I do not. I know you could build lightsabers. I didn't know you could build droids.
Oh, yeah. And they don't tell you about the backpack to carry them around. In fact, I was wondering when he told me that he made these appointments, I'm like, how are they supposed to carry these droids around at the park? All right,
that is a big R2.
This one's head has come off.
Uh-oh.
Hold on. Ah! Don't break droid.
Yeah.
There. All right, so now I have to figure out the on switch, which I think is down here. All right. It will not walk unless I move the feet in a certain way, so I know I will just be able to make it do some beeping. But they get their own... Ah! Don't move! They get their own...
remote control and everything.
Well, turn your head around. No, don't do that. There we go. I put his head on backwards. Hold on. There, wait.
There's a reason I handle the tech stuff.
There is. Oh, wait, maybe I just have him. Why is the head backwards? No, turn the head this way. All right. There.
Mm-hmm.
And they talk to each other. So if you have
That's
more
funny.
than one, they talk to each other. Their heads spin around. Wait. No, not the whole body. Stop that. There we go. The head spins. And then if you don't turn them off, they find each other and they talk to each other. It's
They're like
hysterical.
Furbies.
Yeah. So the thing is, so it will move and like you can put the legs out in the normal way, but I don't want to do that because I'm afraid it'll like walk off my desk. But the crazy part is that they don't tell you that you need this bag to carry it around. Otherwise, you're literally just carrying this thing around with you. And I mean, it's crazy, right? And they're all different styles. They have like the what's the one with the BB-8 one? So my son got one of those and it literally rolls with the head. It's incredible. It's so cool. Do I have robot insurance? Yeah, I'm totally going to need it. Anyway, so those things it was super expensive just to have them build this thing, right? And they have they get to choose their own personalities. They get to choose the voices and like they will be interactive in the park and they light up in certain areas and it's really fun. Yeah. Well, we get there and of course there's the option for these cool bags which have a window in the back so that their little heads pop out when they're on your back. And of course I had to buy the bags, but they don't tell you that. They were $60 a bag.
Oh yeah.
$60 a bag.
$4 Chinese made bags, $60.
$60. They did have a lot of fun making.
Did you hear about the raid in Italy? Oh my god.
What raid?
Dior imported Chinese workers to sleep at this factory making these Dior purses that are selling for like $2,400, and they're working for like 2 or 3 euros an hour making these bags, and these bags are like I think they said the cost to produce them was like 40 or 50 euros, and they're selling them for $2,400.
Oh my god. In Italy?
In Italy.
Oh, that is Dior. And I've always thought that that's ridiculous. Those bags are terrible. The truth is, though, this was probably made by slaves also. I mean, everything is made by Chinese slaves or somewhere. It's terrible. It's absolutely terrible. Legal Vices says these are not the motions to dismiss you're looking for. Move along. Okay. All right. We're moving along. Let's go to TMZ. Because TMZ is going to give us the lowdown on what the heck happened here. Sarah Adams, thanks for the 2. Got 8th tattoo this weekend. I'm gangsta AF. 8th tattoo. Good gravy, lady. You'll have to send a picture on Twitter. I'm sure that it's great, whatever it is. Okay. All right. Here we go. Jury voted unanimously to acquit on murder. Holy crap. Let's read this, shall we? Karen Reed may be tried again for the death of her boyfriend after the judge declared a mistrial. But murder charges may not be on the table. I actually don't think that's accurate, Brad, because the judge denied her this verdict. There was never any official verdict. Legal Vices, I didn't know that you'd already covered this. Did you already cover it? I have been in the shower trying to get my hair dry and all that. I have no idea. Jeff, if you want to come in here, please come in here. I would love to have you in here. Let me, I'll send you
it.
Yes. Thank you. Thank you, Brad. I don't think this is actually true because if the verdict wasn't registered, if it wasn't entered, she doesn't actually have a verdict. And we're going to get to why it wasn't done. According to the defense, a vote on the murder charge was 12-0 in favor of acquittal. Reed's lawyer, Alan Jackson, has just filed documents arguing prosecuting Reed for second-degree murder a second time would amount to double jeopardy. Shockingly, when the judge declared the mistrial, she didn't say anything about the jury's vote on the murder charge. And by the way, Larry Forman of DUI Guy, he was losing his freaking mind when that happened. I remember I was watching his coverage. And it was like, as soon as it happened, as soon as the judge was declaring a mistrial, he is screaming at the top of his lungs, pull the jury, do your goddamn job, pull the jury. Like, what the hell, Jeff?
Hi.
This is not accurate, is it?
Well,
murder charges may not be on the table. How could they not be on the table?
That means might not be, because that was the whole subject for this motion to dismiss. was that that's what they're arguing. You cannot try these again because it's double jeopardy. It doesn't matter if they was a checkbox or not on the verdict form. The fact that all 12 of them unanimously agreed means that it should be double jeopardy. That's what they're arguing in their motion to dismiss.
But did they write this down anywhere? Is the
They're saying
jury
that's not
on
important.
record?
There's case law that's not important. It's the fact they reached a meeting of minds, and whether it was memorialized on paper or not.
But the judge never polled them. We don't know what they said.
But
so
there's
if I'm the prosecution,
three jurors came forward and said it was unanimous, not guilty.
Oh, 3 now. I thought we only had 1. Okay.
Yeah, you got to read the motion. You got to read the motion.
I know.
Itself.
I read it, but I thought it said juror number 3, not 3 jurors.
No,
okay.
There's juror A, juror B, and juror C.
All right.
One approached Jackson. Two informants approached Yannetti.
Holy crap. Holy crap. All right, Brad, let's get over to the where did you put it?
I gave you the one. Let me see if I can
get
this into a PDF or something.
It's okay. We can just put it in a new tab and make it bigger. There we go. All right, let's move over here. There we go.
Is this the PDF or just the screenshots?
It's the screenshot. I don't have
send you the PDF.
Sure.
Runkle was looking for a PDF.
I sent it to him. Yeah.
I, David R. Yannetti, do hereby depose this and state that the following is true to the best of my knowledge and belief. 1, I am an attorney licensed in Massachusetts since December 20, 1989. My main office address is, I was retained to represent defendant Karen Reed. On July 3rd, I received communications from 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. To my knowledge, Informant B and Informant C do not know each other. On July 3, Informant B sent me a screenshot she had received from someone, hereinafter Intermediary B, of text messages that the robot's even pissed off, that Intermediary E had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. What was the second charge?
That was the...
Hang on.
That was the driving under the influence manslaughter thing.
Yeah, manslaughter, yeah.
Mm-hmm.
It was 3 that was the driving.
That was
under
leaving.
the influence.
3 was leaving the scene of injury, death,
or
injury, death accident.
It was not guilty on second degree and split in half for the second charge. When the
judge
judge
sent it to you.
Okay, thank you. When the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. What's the Hernandez thing, Jeff?
That's the instruction that was given to them, saying like you say you can't reach it, but now you have to go back, think about it from the other side. If you weren't able to convince other jurors, then maybe there's a reason for it. Think deeply about it. That's what they've been calling the nuclear option. Once that goes out and they come back again, it's over.
It's over.
They're required to declare a mistrial.
Yeah, on Monday the 1st, they came back. They were like, "Yeah, we're hung," and then they read it, and then they went to lunch, came back, and they're like, "Yeah, we're still hung."
Unbelievable. I am so pissed that she didn't poll the jury. All right, I see that you sent me the motion to dismiss. Let me get the affidavit. The affidavit's the thing that I'm reading right now, right?
Yeah.
Let me open
the motion
that.
has all the timeline, everything, and the motion is very, very detailed.
All right. We will read that.
Yeah, it's the Tui Rodriguez, but it's not a Hernandez. It was a
So Hernandez was a scrivener's error, if you will.
No, it was quoted from text messages. So the texters didn't know what it was called.
All right. Here we are. I see Hernandez thing. This is a quote. That Hernandez thing. To look at the other side, it turned into a bully match. Ooh. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. What's a counseling form?
For me, if you want to get free counseling, talk to these people.
Yeah.
Oh, really? Like if you really? They thought that they were traumatized by the trial? I guess that happens.
You can be. I mean, when you're literally charged with
photos and stuff,
with the you have all the terrible photos, and then you've literally sent someone to jail for the rest of their life, or sending someone to death. It's gonna be traumatizing.
It's like the contestants from Hell's Kitchen. They get sent to a cottage to decompress and get counseling and whatnot after getting yelled at by
getting yelled at by the chef. I would need counseling if I got yelled at by him every day too.
What are you?
An idiot sandwich.
Okay. Although growing up with my dad, I should be used to it because Jeff and I can attest that we both have fathers who probably put us through most of that, right?
Yeah.
Well, let's see. It toughened me up, I tell you. It toughened me up. I've heard more times than I can count. You're a mope. Stop being a mope. All right, let's see. I thought the prosecution, based on the first name of juror B, given to me by informant B, I believe I am able to positively identify which juror he/she was and confirm that he/she was a deliberating juror. On July 3rd, informant C contacted me to say that he/she personally knows juror C as they used to work together. Informant C and juror C also have a mutual friend, hereinafter intermediary C, who is a current coworker and friend of juror C. Informant C told me that he/she had posted something about the Karen Reed case on Facebook July 1st. He/she told me that he/she believes that post led intermediary C to text her, and inform her that juror C was a deliberating juror on the case. Informant C told me that he/she thereafter reached out to juror C via text message and discussed her experience as a juror in very general terms. They discussed what an exhausting experience it was, and that juror C was relieved that it was finally over. Intermediary C told informant C that juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Oh yeah, that's not going to get leaked. Somebody didn't record that for sure.
Mm-hmm.
Today, informant C sent me 3 screenshots of a text message exchange that he/she had with intermediary C. Informant C told me that intermediary C was reporting to her during this exchange what juror C had revealed during the Zoom meeting. The text message exchange reads as followed: "No consideration for murder 2. Manslaughter started polling at 6-6 and then ended in a deadlock at 4 no, 8 yes. She was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, she voted no because the cause of death was twofold of hypothermia and head injury, of which she was convinced that the vehicle did not cause both. The whole jury felt very intimidated by Higgins' presence at the end."
That should be Albert. That should be the
Albert?
Yeah.
The Alberts. Okay. She's not sure what she's going to do. She's going to lay low for a couple days and see where it takes her. Hasn't ruled out anything. Come forward. Talk to the media. Tell them about your story. I mean, really, a woman's life is at stake here. The jurors all have a group text going. Informant C, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip. That was all confusing. Intermediary C, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. Yeah, we said that from the beginning. Informant C, what a great experience for her. Amazing that they let the Alberts in the last day. I agree. That was crazy while they were staring down the jury.
All right. I got to interrupt. I mean, Chad, everybody going, oh, what's it with the pronouns? They're saying he or she, so they don't identify.
So they don't
it's
identify.
A male or a female. It's not a pronoun thing, people.
And anyway, that's the correct way to do it. That is not the new way to do it. The new way would be to just use they, them, which is totally incorrect.
Yeah.
He, she is the right grammatical way to do it when you don't know the sex of the person you're speaking of.
And when it's in those braces, brackets, that's how the author is saying, I changed this or I added this.
Yeah. Right. She felt very honored to be part of it. She was, and then they redacted the physical description of the juror C. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. Informant C said that's the way it should be. Of something, knew it was an intelligent jury. They will be studying this case in law programs for years to come. Something how not to investigate and try a case. Yeah, I can agree with that.
Yep.
If they all agreed on no for murder too, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she's retried on that charge. So Jeff, you're saying it doesn't matter if it wasn't put into writing?
That's the argument. It's all in the motion. When you read the motion, they lay it out very, very nicely.
All right. Based on the
I completely
description
agree with it.
Based on the description of Juror C given to me by Informant C and confirmed by the redacted content of the above text message exchange, I'm able to positively identify which juror he/she was and confirm that he/she was a deliberating juror. All right, so let's go to the motion to dismiss. Now comes defendant Karen Reed, by and through undersigned counsel, and hereby moves this honorable court, pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights, to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and, alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Ms. Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. I have a question, Jeff. Yes. Why is this judge so bad? Why is Bev so terrible that she didn't pull the jury and actually take care of this right then and there?
She's not very smart.
Or she's corrupt as fuck. Because I'm sorry, this is not a basic mistake. Like, this is not a mistake that's like, oh, well, it's understandable. I thought the same thing. Larry was losing his damn mind while she's
we all were. Yeah.
Everyone's losing their minds, and it's like, well, yeah, why aren't you asking them where are you? Where do you stand?
And it goes back to the jury form too, because everyone pulled up the model jury form and they're like, this is the standard, guilty, not guilty, next to each other for each charge. And she's like, no, we just do the one not guilty at the top, and then you don't worry about it.
It's so crazy. It's so crazy. Yeah, it's not a harmless error. Exactly. She should be disrobed. Is that a thing? Actually, I don't want to see Judge Bev.
Please no.
Never mind.
Yeah, not phrasing.
As long as she's wearing something underneath. All right. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people, Erlanger v. United States. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the 5th and 6th Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. That sounds like their entire case. Pretended offenses. Prominent among the reasons colonists, we're going all the way back to the colonists, holy shit. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them, in many cases, of the benefits of trial by jury. Damn, I get all weepy when we start talking about colonists and stuff. I mean, he's hitting all the right buttons.
After the 4th of July.
As John Adam, here we are. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The Double Jeopardy Clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb, Bluford v. Arkansas. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continued state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. You know what Bev's going to say? You know what she's going to say? She's going to go, well, I was tired. I was tired. I was exhausted. So, you know, counselor. I mean,
Lay
she
off me,
was
man.
so nasty. That woman. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Ms. Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Well, geez, that's kind of significant. This judge should never be allowed to judge anything again. Can we send her back to, I don't know, what did she do before this? Was she a prosecutor probably?
Probably.
Oh God, I don't want her doing that either.
You really
I'm
want
sure there
someone
are
affiliated
openings.
like that?
I'm sure there are openings at Dunkin' Donuts. Perhaps Bev should go work there because she's tired all the time. She needs extra caffeine. All right. Where was I? Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. Yeah. But I'm concerned, Jeff, that because they didn't poll the jury, there's going to be shenanigans. There will be jurors who are intimidated by Alberts or whoever who say, I didn't say that. And then what? Because aren't they going to have to call the jury back in and ask them about this?
Well, that's what this alternative is. First, they're saying just dismiss it. But if you still think there needs to be factual inquiries, then he's going to ask later on in this, let me bring in these 3 jurors and you can voir dire them and question them all you want about what they heard, what they saw, and what happened in that jury room.
Wow. See, this all could have been solved that day that the mistrial happened. She could have done this then when she should have. God dang it, this makes me mad. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held. Oh, this is the part you just said was here. Yeah. I see how my brain works. I'm ahead of the game, Jeff. I'm ahead of the game. I just need to keep reading, though. The defense respectfully requests a post-verdict inquiry to be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. Background. On June 9, Ms. Reed was charged in 2022 with 3 separate indictments with murder in violation of whatever law. Count 1, vehicular.
And see, that's where that's where this is important. It was 3 separate charges with 3 separate jury forms.
And they only got 1.
No, they got 3 separate jury forms.
Well, then why didn't we get the other 2?
We did.
They brought them back. They gave them back to the judge with their not guilty.
You mean when they handed no? See that they didn't. They didn't
hand this back. Is what I'm saying. Why didn't they?
But see, this is why it's important that it's important to remember there was 3 separate charges with 3 separate verdict forms. That helps the understanding here.
Who fucked up is what I want to know.
Didn't they combine them all into a single page though?
No,
because they had
that was charge 2 had the main vehicular manslaughter with the 2 lesser included on the same form. That was the one they had the issue with. Was the second confusing?
Oh my God. Form. All right. Well, I'm confused as to why the not guilty forms didn't come back to the judge then. I'm confused. But that's usual. Count 1, vehicular manslaughter in violation of MGL whatever law. Count 2, leaving the scene of personal injury or death in violation of the law. A jury trial began on April 16th. On June 25th, the jury began deliberations. On July, after the longest state's case I ever saw in my whole damn life, with the most retarded witnesses who all said they butt dialed each other and answered with their butts multiple times. They were so unbelievable. They were so uncredible. I'm shocked that this jury was arguing at all. Shocked. I would have, as a jury member, I would have been like, can I convict that woman that looks like Skeletor? Because that's the one I want to convict. What was her name?
McCabe.
Jennifer McCabe. I think Jennifer McCabe should go to jail. That's what I think. On July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. See Affidavit 7. The note was not presented to counsel for review. What the actual F? What do you mean? What does he mean it was not given to?
They didn't see the note before it was read out in court.
Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. See number 1. While the juror's note read by this honorable court indicated the impasse was on charges, it did not say whether the charges were those within count 2, the multiple ways to find guilt on count 2, or extended to other counts. The affidavits attached herein indicate the former, not the latter. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictments. Lock her up. Lock up this judge. Put her away forever. I'm so pissed at this.
It's huge. It is big, and it goes to what all of us law tube people were saying when it happened. You can't just say there's 3 separate charges, mistrial, go away, because you can't try someone twice for the same thing they've been acquitted, and that's what they're arguing here. She was acquitted of this.
Is this what they do in Massachusetts? Is this like usual? I think we need to find out if other mistrials do not pull the jury. Like, are judges just like willy-nilly? Oh, mistrial, go away now. And then we'll just try you again on the same shit. I mean, what? I'm horrified by what I have learned about Massachusetts during this trial. I have learned that the police in Massachusetts can drive and do drive drunk in their police cars and get so drunk they lose their guns, they lose their badges, and they keep their jobs. That they can go through, they can be the lead investigator on a case, calling the suspect a retarded cunt 8,000 times, look for naked pictures on her phone without a warrant to do so, and still, it's fine. Hell?
He's in a load of shit right now. So
well, I know, but I doubt they're going to do anything to him. His Proctor's hearing is on Monday, next Monday,
sounds about right.
If I'm correct.
I think today.
Oh, is it today?
I think it might be today.
Oh, they're rushing that through. If it's today, they're rushing that through. And I don't know what they're going to do with him, but I have a feeling that he's just going to be reassigned somewhere, and they're going to hope that it blows over, because he's got major support from the union, which I cannot even believe. Like, I understand unions and like what they're for and everything, but they really need to, in order for unions to keep a decent reputation, don't stand up for guys like this. Throw guys like this under the bus, because this is not, as a cop union, you should never want a police officer who behaves the way that Proctor did. No way should you want that. Ugh.
The unfortunate thing is, from a union's perspective, if the union will throw one of their members under the bus, then they lose the argument that they stand up for the people who get accused of things. So
this dude did it. It's all over his text messages. These people collected evidence in solo cups. They should all lose their badges. They drove drunk. They drove their cars, their police cars, drunk. They should all lose their badges. This is so sick. The things I have found out about Massachusetts in this case make me horrified for the residents, for the citizens of Massachusetts. You guys are living under some kind of police tyranny there. I'm sorry to say it, but my God.
Well, we're reading about judicial tyranny here now.
Yeah, police tyranny, judicial tyranny, prosecutorial tyranny. I mean, the list goes on and on.
Who cares about that independence thing 250 years ago? That doesn't mean anything anymore.
I'm giving myself a damn headache. Okay, I have to stop yelling.
Drink more water.
I know, well, I'm drinking cold brew. Does that help?
No. Well, caffeine does help a little bit, but...
A little bit. I should have taken an allergy pill. I think it's allergies. All right, anyway. The following day, on July 2nd, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that he wished to inform him of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic the count second-degree murder was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such a crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury and death. Another day later, on July 3rd, Attorney Yannetti was contacted by 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. David R. Yannetti, Affidavit 2. Informant B sent Attorney Yannetti a screenshot she had received from someone, hereinafter Intermediary B, of text messages that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. I wonder if that was supposed to mean or even thought she hit him.
Yeah.
Yeah. Well, whatever it was sick. So,
Yeah. Informant C, well, because it's a repeat, I'm thinking that was like a phone ad.
Yeah.
I think it probably meant or even thought she hit him.
Yeah.
I was not convinced that she hit him either. Informant C had been in contact with another individual, Intermediary C, who was a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with Intermediary C regarding what Juror C revealed in the Zoom meeting. No consideration for murder 2. Manslaughter. Started polling at 6-6, ended in deadlock. All right, we already read this. Argument. The jury's
here we go. These are where we answer. Excuse me. This is where we answer your questions about what if it's not written and all those other things.
Okay.
And why it's important to us 3 separate charges on 3 separate verdict forms.
The jury's unanimous conclusion that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Taylor, 486 Massachusetts at 482, Martinez v. Illinois. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. Commonwealth v. Babb. The mere presence or absence of check marks on a form is not dispositive. Ooh.
So there you go. So whether or not they mark it on a form isn't important. The question is, was there actually a resolution? Was there a meeting of the minds? Did they all agree on this?
Oh God, but at this point, if there's nothing on a form, some of them could say we didn't agree. They could just lie now. Maybe I shouldn't point that out. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations.
If you bring 9 people in to say, yes, we had all agreed it was 12, and then you get the 3 who are lying saying that we didn't, then you take the evidence, I would imagine.
I don't know. I don't know. I mean, they better hope that the McAllens didn't get to these jurors already. They better hope that they haven't been intimidating these jurors into not talking or changing their story. And I don't trust that they haven't done that. Those people, there's something wrong with those people. Like, clearly, there's something terribly wrong with all of them. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. David Yannetti, Affidavit 4, reflecting text message from Juror B, it was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. Sick. Reflecting Juror C's statement relayed by Intermediary C that there was no consideration for murder 2 and Ms. Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. Is Bev the one who's going to have to rule on this, though, Jeff?
Yes. Yes.
Oh, for fuck's sake, she's totally going to deny them. They're going to have to take this to an appeal. You know that, right?
You could interlocutory that.
Well,
this
you
is
wouldn't
pretty
need,
strong.
would you?
I
Is
would.
it interlocutory for in the middle of a trial?
It's in the middle of the case, and if you're trying to file a motion to dismiss based on those 2 counts before everything is finalized, then you could appeal that particular decision.
That particular thing. Yeah. Well, I don't know. You think it's strong enough, Jeff? You think she's going to have to?
She's got to do something. This looks pretty damn cut and dried to me. And that may just be me going, this is what I was saying the entire damn time. That might color my thinking a bit, but it looks pretty damn solid to me.
Okay. Well, I hope so, but she doesn't inspire my confidence. I'll just put it that way. Bev does not inspire confidence that she will do the right thing, because she should have done this before declaring the mistrial, by the way. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. 566 U.S. at 60304. The court sent the jury back to continue deliberations and, when the jury remained unable to reach a verdict, declared a mistrial.
So that's where this is where the important distinction begins. That was all one deal: capital murder, first degree murder, or manslaughter. That was the lesser included kind of things. It was on the same charges on the same verdict form, which is different than here.
The Supreme Court. So you're saying that was all on one form?
Yeah, they explain that here in a second.
Yeah. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the juror's statements reflected a final determination that
That persisted through the end of deliberations.
That persisted through the end of deliberations. Even assuming arguendo and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. See Commonwealth v. Tinsley. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections. Ooh, that's kind of concerning.
Right.
That the Declaration of Rights doesn't include the double jeopardy clause, but the United States Constitution it has supremacy over state.
Yeah, and they're saying anyway, the state statute and other things have always done that.
Yeah, have always done it. So by default, basically. B, re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Wait. Did I understand that? The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. So not several tribunals, but
by one. Yeah.
By one. Taylor, Oregon v. Kennedy. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Ms. Reed did not consent to the declaration of a mistrial. See the Affidavit 9. See also Commonwealth v. Edwards, rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. Absent the defendant's consent, state and federal double jeopardy protections bar as a general rule retrial of a defendant whose initial trial ends without a conviction. Ray v. Commonwealth. This rule is rooted in the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Cruz v. Commonwealth. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Jeff,
Yes.
what, in layman's terms, what are we talking about when we're talking about manifest necessity? I don't think I understand that phrase.
That's coming up. The definition of that is coming up here in just a little bit. It's basically,
So yet again, I need
there
to
needs
keep
to be
reading.
a reason, a clear reason to declare a mistrial. So there has to be where the defendant doesn't consent. There needs to be a clear and very important reason for declaring the mistrial. When they're saying there isn't that, they can say what it is and then say there isn't a manifest or necessity to do this here.
Before a court declares a mistrial for manifest necessity, one, counsel must have been given full opportunity to be heard. Oh, and they weren't. And two, the trial judge must have given careful consideration to alternatives to a mistrial.
So in other words, there must be no alternative but to declare a mistrial. That's your manifest necessity there.
Well, and I think there was no alternative than to declare a mistrial. I think that part is sufficient. But
oh no, that's what they're arguing here. They're arguing it wasn't necessary.
That wasn't necessary.
There was an alternative. Polling the fucking jury. That's
they
your
should
alternative.
have. Yes, they should have polled the jury.
Yeah.
Absolutely. But I mean, they still would have been a mistrial on the one count, but not the other two.
Yep.
Yeah. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. I agree.
They were asked, though, because before they read the whatever charge, the Allen charge, she asked the attorneys, and the prosecution said they haven't even sat for an hour per day of the proceedings, and then they went to the defense. Yeah. They're like, well, if they're deadlocked, they're deadlocked.
They're talking about when she declared the mistrial.
Oh.
At that point, they have to say, do you guys agree with me declaring the mistrial? And they should let them argue back and forth.
And she didn't do that. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. See the affidavit. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Commonwealth v. Horrigan. See also Picard v. Commonwealth. Finding no manifest necessity, where no opportunity was given counsel to argue the propriety of the question or of the necessity of a mistrial. Commonwealth v. Stewart. Finding no manifest necessity, where the trial judge first ruled that he was going to declare a mistrial and then, almost as an afterthought, unenthusiastically asked whether counsel objected. Unenthusiastically. It's funny. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Ray 463 Mass. Here there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so, and the jury articulated its verdict consistent with the statements of juror A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, it's a hard word to say, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. Yes, United States v. Mespelude, whatever that is.
I'm sure that's how you pronounce it.
I'm sure that's it. Mespelude, like in France. See also Wallace v. Havener. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached an agreement. Yeah. The Supreme, I mean, this is basic shit.
Yeah.
Right? This is this is legal 101. Like, you learn this your first year in law school. This judge, oh my God. The Supreme Judicial Court's holding in Commonwealth v. Ross.
This is a Massachusetts case they're quoting here now.
That courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here.
That's the one with where all of the lesser included are on the same verdict form.
Oh,
they're saying this is different.
This is as the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged. Oh, shit. These were separately charged. Carries a significant potential for coercion. See also Bluford. I feel like I need to read Bluford. Bluford keeps coming up. Declining to require court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses where, under Arkansas law, the jury's options were limited to 2, either convict on one of the offenses or acquit on all. All right, and then we have a footnote. Let's go down to the footnote. Massachusetts law, to the contrary, clearly permitted the jury to return a partial verdict on some, but not all counts. Oh, it was too confusing. It was too fucking confusing. We said that. I said that. I said it. I was arguing this on Twitter. It was too confusing. The jury form was stupid as hell. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here, the jury was asked to return 3 separate verdicts on 3 separate counts. Distinguishing situation where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. You know, I will say, though, Jeff, and I watched all of your coverage and everybody's coverage. I watched everybody's. So I watched the same thing over and over and over again. Yeah. I never knew or could discern that there were 3 separate forms. It always appeared that there was one.
There was only one that was confusing, because the count 1 is guilty of second-degree murder or not guilty, and the same with count 3. Count 2 was the only one with the lesser included. So that was the only one that was confusing. So that was the only one that was brought up.
That's the only one that they talked about, right?
Yeah.
Okay. No similar danger is present at here, where the jury was asked to return 3 separate verdicts on 3 separate counts. Distinguishing situation where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. In this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straightforward and, the defense contends, constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Yeah, you would think.
Yeah. It's obvious that's what you do, because if 12 people say, yeah, we don't think we think they're not guilty on they've been acquitted.
Yeah. I mean, it's inexplicable why she didn't do this.
Because literally you'd be saying, all 12 of us agreed she wasn't guilty of second-degree murder. Now let's go retry her on second-degree murder.
Oh my God.
That's literally what you're saying.
So I just posted in the private chat the verdict form for the charge 2.
For charge 2. Okay. We'll look at it in a bit. Indeed, the Supreme Judicial Court has explicitly stated, where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts, despite deadlock on the other counts. Okay. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, jurors A, B, and C, supra, the defendant asks for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty of counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. Commonwealth v. McCallop. And that's also Massachusetts. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that the post-verdict inquiry is equally warranted in the present context. Just as the court in McCallop approved questions as to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Miss Reed was not guilty of counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the double jeopardy cause and its related state judicial protections. I mean, yeah. Conclusion. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court issue an order dismissing counts 1 and 3. Damn.
I want to see what kind of argument the prosecution comes up with in their response to this.
Do they have to respond?
They get a chance to. But I mean, this is just cut and dried, as far as I'm concerned. Supported, each point they brought up is supported by Massachusetts and federal law.
Well, yeah, I mean, I thought that the motion is the motion's amazing. The motion's really good.
Yeah.
I mean, it made me hit the anthem button, for crying out loud. It's really good. It's really good. It makes you, and here's the other thing, and I will say about that. If this is true, if this is what happened in the jury room, then I have regained my trust in juries. And I had lost it after this. I was like, that's it. I'm going to have a bench trial. If I'm ever on trial for anything, I'm choosing the judge because juries are fucking dumb. Like this. How on earth do you not see that there is reasonable doubt all over this MFR? Like it's all over it. It's everywhere. All right, listen, I'm going to come back and read super chats in just a second. In the meantime, you guys take over for me because I have to take a bathroom break. Too much cold brew. I'll be right back.
All right, so
don't know what to say after that.
I'll pull up this this jury verdict form because when I was looking at this, I didn't see offense 002 up here at the top. So yeah. Because there's 3 options here, I thought this was the 3 counts, and having not read this the entire way through and seeing all of these extra check marks, I'm like, oh, that's the lesser includeds. Because of the way that it's formatted. Yeah. So the fact that this is just one charge is even more offensive in how it's presented.
Yeah, and this is the problematic one before they revised it. And had to, so, I mean, she had to give that ridiculous, 15-minute long explanation of how to fill out the forms.
Right.
Simply could have been rectified if she would have said 2, guilty of offenses charged, manslaughter while operating. Should be like number 1 shouldn't be there. Not guilty shouldn't be there. Yeah. And just put 2, manslaughter while operating motor vehicle under the influence. Guilty, not guilty.
Right.
If not guilty, go to 3.
Right.
Then do if not guilty, go to 4. If not guilty, mark not guilty of all charges, and that's all you had to do. That's all the form had to do. It didn't have to be a 15-minute explanation on how to do all this stuff.
Right. And that the amount of time that was spent arguing over that was, I'm surprised because we saw what the model jury form was supposed to look like. And the fact that they chose to ignore it and go with this format is boggling in my mind already. They put out those model forms for a reason because there's case law to build how it should be looked at. And if you stray away from that, you only open yourself up to appealable issues.
And it also kind of works the other way too. The model form has the not guilty of, it has the longer explanation, whatever it was. But that also was not that clear. It was less confusing, but it becomes institutionalized where, it's a little confusing, but that's the way we've always done it. Law doesn't like changes. Law doesn't like innovation. Right. Hell, there's still wording. If you look at stupid things like powers of attorney and stuff, you'll have whereas this year or comes now all men present. You're like, that's just shit that has been said since the 1300s.
Right.
No, by all men present. It's like, well, we've been doing it for 800 years, so why should we change now? Or 900 years, or whatever the hell it is, lawyer math.
Well, I think if you think about it, when the founders created the Constitution, they were under the impression that it would be fundamentally different from the way it was initially implemented because they provided the ability to amend it and change it as needed. And for whatever reason, they chose not to do that. So in the same way, law could be changed, but people just don't. or
nobody wants to be
and
overruled. But Megan, questions?
I'm back. Yes.
I mean, do you have questions? It's getting 2:37 a.m. here.
I don't think I do. I think you can go. I mean, if you need to sleep,
get out. Off you fuck. That's what you're telling me.
Off you fuck. No, I don't think I do have any questions. It's pretty straightforward.
It's very well written. It's very well straightforward, and it's pretty. Like, I don't know how much of it is just me, agreeing with it and saying this since the incident, which the verdict is now the incident, not the murder. The incident of the verdict happened is exactly what I was saying, and I don't see a way around this.
Yeah.
If that is true, she was acquitted of second-degree murder, whether or not you put the damn checkbox on the box or not.
Yeah. Yeah, that's pretty interesting to me. Although I'm worried about jury intimidation. That's my biggest worry, because this is now.
Like I said, you've got apparently they're all in a chat room together.
Well, that's true.
Now, yeah.
And that can now be discoverable, right? I would think.
And they said, that they were all amicable and they weren't. One of them said it became a bully fest after they read the Rodriguez charge.
Right.
They're still saying they respectfully disagreed and stood their ground and stuff. So it doesn't sound like there's any serious animosity with the jury.
Right. Well, of course, that could change, especially with public attention, etc. So I hope that that's not the case. But we'll see. We will see. How long do you think until the prosecution responds to this? What is their time limit, do you think?
I don't know, but I would guess probably somewhere around 30 days.
Ugh. Well, I hope it's.
What was it in Maya's? In Maya's case, that was about 30 days, wasn't it?
I don't remember. God, that was too long ago. I can't remember. Are you going to be covering the Rust trial, Jeff? Are you doing that?
Yeah.
You are. All right. So, are you doing it live?
Mostly.
Okay. Cool. All right.
Well,
I still haven't
the same afternoon format recap.
I haven't decided if
session,
I'm going to do that yet.
Then the next day I'll do the afternoon session at 1.25 speed until I catch up with the morning session the following day.
All right, cool. Well, off you fuck. Go to bed.
I'm going to.
Thanks for stopping by.
Jeff.
Bye, guys. Have a good one. See you.
All right, let's see. Hey, Joe, thanks for the 10. Says, welcome back. Replacing some cheese that the mouse stole. Well, to be fair, I signed up for it. Sarah Adams, thanks for the 2. If you need a bodyguard, page me. That new tattoo is probably intimidating, right? Wendy Bono, member for 4 months. Hello, Megan. Brad, sounds like you had fun regardless of the ARP. We did have fun. There was a lot of new stuff. I will have to tell you about some of the new rides that are incredible. Audrey Little, welcome back. Beautiful Megan, I missed you. Well, thank you. I missed you guys too. New member, Taz, became a new YouTube member. Welcome to the Fox Den. It's weird in here. Get ready for it. Sebastian Mueller became a YouTube member. Welcome to the Fox Den. I only lost one chicken while I was gone on vacation. Only one chicken died. Palmyra Productions became a YouTube member. Thanks for the ad. And actually, I'm not sure why. I think it was just old age. It was one of the older chickens, and I did have someone watching them, so I don't know what happened. But one chicken keeled over. Diana 71, thanks for the 5. I hope you enjoyed your vacation, but I'm so glad you're back. Me too. And we have to talk about the new schedule. I don't know what it's going to be like because I am, my kids are home for the summer. So during the day, it's going to be rough for me to do streaming. Starchasm, thanks for the 10. I keep asking why they didn't ask how to complete the form and not that they couldn't agree on anything. Now they have outside influence. One said reading Facebook posts and talking to others at their point. Yeah, they're allowed to do that now. So I don't know. Taz, thanks for the 2, sending love and hugs to Megan, Jeff, and Brad. Thank you for that. Appreciate that. Wendy, a member for a month. Welcome back, Megan. Thank you, Wendy, for being a member. Ninja Puppy, thanks for the 5. Once again, thank you for the great coverage of these interesting cases. You're welcome. This case really pissed me off. I wish I had had more of me. I wish there was like a clone of me so I could have covered this trial, because it was something. I sure had fun watching the coverage. The coverage was just, this trial was just crazy. All right, so let's talk about how crazy this coverage actually was. Taz says, I've been a member while you're on vacation. My membership ran out. Hugs. Oh, well,
Whoops.
That's okay. Become a member on Locals, meganfox.locals.com. Oh, God, I forgot to open the live chat. It's there. I just don't have it on my screen. The live chat is open on Locals, meganfox.locals.com, but I'm just not in it.
Did you open the ghetto and not remember your locals?
Yeah, I did. I did open the Rumble.
The ghetto is no longer ghetto. Locals is now the ghetto.
How are you, Rumble? By the way, it's good to have you here. I think I have Rumble open over here on this screen. Yep, there you are. There's Rumble. All right. Now I got to go back over here. What is going on? I can't open Locals all of a sudden. Uncaught client exception.
That's
strange.
Unfortunate.
Yeah. It's weird. Yeah, log in. It says success. Well, log in. There we go. All right. I don't know. Just the computer had a hiccup. All right. There we go. There's the chat. All right, Locals chat. Good for you. All right. So Larry is supposed to be here at some point. I think he's going to pop in when he has a break in the Rust trial hearing that's going on today. So hopefully he'll make it over here, because his reaction is probably going to be hilarious. All right. I want to show you a court TV panel thing that is really stupid, and see if those of you who watch the Karen Read trial notice what's totally stupid about this court TV coverage. All right, here it is. Present, share screen. There we go. All right. First of all, let's look at the title of this. Evidence the jury did not see in Massachusetts v. Karen Read. Did not see. All right, let's hear him set this up, shall we?
Believing Karen was framed, clear things up, and show the truth to the things got personal. Here's the only way that you can prove your case.
All right, here we go.
It wasn't. Of justice. That's your real.
By the way, what is his name? He drives me absolutely bonkers.
He looks like Blagojevich with a better haircut.
Real takeaway. In our system of justice, for something to be proven, it needs to be proven beyond a reasonable doubt, and it wasn't. And it wasn't, because the jury came back and said, no, we don't all 12 agree.
Well, now we know they all 12 of them agreed on a couple of things.
And that's the only way that you can prove your case in our system. A prosecutor has to bring in the evidence, convince all 12 must agree. It didn't happen. So we're back to square one, where nothing was proven. She's presumed innocent, and it's up to prosecutors to try again. The really sad part of all of this.
Vinny Politano is his name. Some of you really like him. But wait till you see how dumb this is. I don't even believe he watched the trial after watching this.
This is that the family of John O'Keefe, his mom, his dad, his brother,
they deserve the truth.
One way or the other. Didn't even need to believe that there were really two cases being tried at once. Unfortunately, someone needs to come forward with more information to get this jury to the truth.
All right, now let's hear about what information he thinks was not presented at trial, because this is so crazy.
John O'Keefe's cell phone. Great. A little bit of a buzz. And what the data said about where John O'Keefe's phone was and what it was doing. Okay? It ended up with a little bit of a battle of the experts. But there was a good foundation built around John O'Keefe's cell phone. Great. He's the victim in the case. Karen Read's the defendant. Phone calls from Karen's cell phone tracked her movements on the night of January 29th. They used this also to find surveillance video of her car. And we know when she got back to the house, when she hooked back up with the Wi-Fi.
Okay, so he's basically laying out that, yeah, we had John O'Keefe's cell phone and we had Karen Reed's cell phone, but what about all those other people?
People in the house. But data that says she is somewhere at some time. Well, what about the rest of the people in the house? There's a bunch of them. They all testified. But at the end of the day, their testimony wasn't enough. Either the cross-examination or the direct wasn't enough to convince the jury one way or the other.
Look at all these liars, by the way. This is a panel of liars right here.
Right.
Collectively.
Could you track the phones of everyone at the Alberts house? Well, maybe if they hadn't destroyed them on military bases.
Mm-hmm.
And by the way, they did. This one right here, Caitlin Albert, her phone was tracked and she was in places she said she wasn't. So what, does he not know this? Because she was at the high school after midnight and she said she was at home. But the data from her phone, which they had, said that she was at the high school.
So isn't there some way that someone could help us track where all these people were?
Is he out of it? They did.
Yeah, he's being obtuse at this point.
Oh, come on. And they don't even, in this entire thing, he does not mention any of the butt dials and the bullshit.
What they were doing?
Or Caitlin.
In the hours in question?
Yeah, we know what they were doing.
Well, let's find out.
Calling each other.
Joining me tonight, he's the best criminal defense investigator. Charles Middlestat is handpicked by me. House. Most people have phones. As we sit here tonight, getting ready for a new trial, is it possible, like logistically, I'm not going to get into the legal wrangling yet, but logistically, to find records from cell phone towers or somewhere else where you can help track the location of the other people who were in the house that night?
There certainly is, Vinny. And again, I didn't follow this case gavel to gavel, so I don't know the full.
So I have no idea that there was this information presented at trial. I'm just going to say that we could have done it.
Scope of the testimony or the evidence in the case, but
all right, blah blah blah.
Need to determine offenses on the carrier each. So some of those records.
Basically, he says, yeah, it depends on the carrier, but some of those phones aren't in existence anymore, and so we don't know if they'd be able to even have it. Some of the carriers don't save that information, and we know. And now look at this part. This part kills me.
Flurry of activity on those house is the call detail records, because if something happened inside of that house, I suspect that there would have been a flurry of activity on those phones. You would see text messages. You wouldn't see the content because the content's not going to be within those call detail records. The content would result.
Why isn't Vinny jumping in here going, there was a flurry of activity on those phones and they all denied it and said they were butt dials. Come on
those phones, and you would actually need to have physical custody of those phones in order to image them.
Well, some of those phones have been destroyed, so they wouldn't necessarily be available. So some of them, let me ask you this. Let me follow up on something else.
Like,
how does that not sound the worst? It's like, we would be able to get that information, but it was destroyed. Oh, but you mean by
the flurry of activity, though? Look. Okay, let's just. That's enough of that because there's more. So he doesn't even mention the butt dials, the flurry of activity, the calls, the recalls, the callbacks that they all said didn't happen or that they have no recollection of. Now let's go to Legal Bites did a really good, here we go. She did a recap of the spicy texts and butt dials. Let us look at this because she did, let's see, where am I at here? Here we go. Let's hear from the defendant, from the prosecutor's witnesses themselves about the butt texts The butt dials, the 2 a.m. butt dial, the flurry of activity on the cell phone.
Another thing that came up was some more weird phone calls that happened at weird hours. Remember how Brian Albert testified that he had butt dialed Brian Higgins at like 2 a.m.-ish when he was having, I suppose, an intimate moment with his wife, Nicole Albert? Well, here the defense revisited this, and this time, of course, with Brian Higgins.
Your testimony previously was at some point before 7 a.m., that call was the one that woke you up.
Yes.
And it turns out, Mr. Higgins, that was a lie, wasn't it?
No, it wasn't a lie.
When you were asked that question at a previous hearing, you didn't know that the person questioning you had your phone records, did you?
I assume they did.
And you were thereafter confronted with those phone records, correct?
I was asked about them, yes.
And those phone records established that you and Brian Albert actually exchanged not one, but 2 phone calls at 2:22 a.m. that morning, at a time when you claimed you were in bed asleep, correct?
I have no recollection of any phone calls.
That's convenient.
Yeah.
Look at the one that's marked with the QQ.
I see it.
You've seen that document before, correct?
I think I've seen it maybe on a screen, not in my hand.
That was these were the records that were shown to you at a prior hearing?
Yes.
And you acknowledge that at least the one marked QQ is a record of your calls, correct?
It has my name, my telephone number, correct.
And it indicates that on January 29th, 2022, at 2:22 and 35 seconds, you received a call from Brian Albert, duration of 1 second, correct?
Yes.
In other words, Brian Albert called you at 2:22 and 35 seconds, but it looks like you missed the call, correct?
I see the 1 second call, yes.
There's a second call just below that. On the same date at 2:22 and 52 seconds from you to Brian Albert. Do you see that one?
Yes.
And the duration of that call is 22 seconds, correct?
I see that, yes.
So 17 seconds after you missed a call, according to these records, from Brian Albert, you called him back, and there was a call lasting 22 seconds. Is that right?
That's what the records say.
May I approach?
Yes.
So the fact is, you were speaking to Brian Albert in the middle of the night, approximately 3 hours before Mr. O'Keefe's body was found in his yard, correct?
No, that's not correct.
And that was 5 minutes before 2:27 a.m. when there was a Google search for how long to die in the cold, correct?
Objection.
Sustained.
You got real uncomfortable there.
She lied about that under oath in that prior proceeding by saying, I don't remember this phone call.
Objection.
Sustained.
Did you, in fact, tell the truth at the prior proceeding when you said, I don't remember that phone call?
I always tell the truth.
Did you lie under oath, sir?
No, I did not.
Yes.
Would you tell us if
I
you
did.
did?
Objection, Your Honor.
Would you tell us if you did?
You acknowledge that there's a
I love that. Would you tell us if you did?
22-second phone call in your phone records, correct?
That's what's reflected by the record.
And 22 seconds is quite an amount of time. Would you agree?
It's 22 seconds.
But now, when actually asked to explain these calls, you'll never guess what Brian called them.
Now, when you were asked about this and you were shown these records, that prior hearing, you had an explanation for what that 22-second call may have been and what the prior call may have been, correct?
Yes.
What was your explanation?
Well, I used a phrase that people commonly used as a butt dial.
Oh.
So you think it's possible that you may have butt dialed Brian Albert for a 22-second call that you're not aware of?
I think it's possible that he could have been inadvertently called back, but I have no recollection of that, nor did I have any conversation with anybody.
But you admitted that you lived alone, correct, Mr. Higgins?
That's correct.
You have an iPhone at the time.
Yes.
Matter of fact, that number for reflecting those records is in fact, or was in fact, an iPhone. Is that right?
Yes.
You already indicated under oath that you don't sleep with your iPhone. You keep it on your bedside table. Is that right?
Most often, yes.
There's nobody else in your room. Is that right?
That's correct.
And you had your ringer on because you were awakened the next morning by a call from Chief Berkowitz, right?
Yes, the ringer was on.
When somebody calls you and you miss the call, there's a notification that shows up on that iPhone. Isn't that right?
I don't know how mine's set up at the time. I don't know.
If you open up your phone app and you go to recents, it shows all the missed calls, correct?
I think you can get to them, yes.
And you know that the iPhone does not automatically call people back. That is not a thing, right? You miss a call from someone, it's not just going to automatically re-ring them.
That is not a thing.
Yes, I think we both know that, yes.
So to call somebody back, you have to go on your iPhone, open it up from a locked position.
Yep.
Navigate to a phone application.
Sure do.
Then navigate to a contact, and then make a call. Correct?
Objection.
Sustained. You can break it down.
Sure.
You can push the
In order
miss
to call
notification
somebody
and it'll
back,
call someone
If
back.
you've missed a call, you first have to unlock your iPhone.
You would have to, yes.
You can do that either through Face ID.
Yeah, but in order to do that, Brad, you'd have to go to your notifications.
Well, yeah.
You'd have to unlock the phone, go to the notifications, and then hit it from there. It's not
You can
just
do it from the lock screen.
How?
All right. I'm going to call you and... Oops.
I cannot open it without putting in my code. I have a missed call. I cannot open it without putting in my code.
Well, but you can click it, then once it unlocks, it will then call the person.
What? I've never had that happen. If I have a missed call, which I just had, it opened up the voicemail and I can call back from there, but I'd have to like push all these buttons to do it.
Yeah, if you have, if they leave a voicemail, but if it's just a missed call, then here.
I don't believe this guy.
We're doing it live. It's still, it's the same here or there. You still have to interact with the phone, and it still has to get unlocked. But
all right, so let's see now. I didn't get a notification that I missed your call. I saw the call, but I didn't get a notification that I missed the call.
If it's closed.
Oh, then it doesn't notify me?
Well, so turn the phone, put the phone to sleep.
All right, do it again. I screwed it up.
We're doing it live.
Where's my button?
Is it there?
We'll do it live. Fuck it. Do it live. I'll write it and we'll do it live.
All right, now it says
I
phone
stopped.
notification.
Then it'll say missed call.
See, now I have to put in my passcode.
Right.
And then it just calls you back?
Yes. See?
I've never seen that before.
It's a thing.
I've never seen that before. I don't like that at all. What if I don't want to call somebody back? It's weird.
Or through a 4 or 6 digit passcode, right?
Yes.
But you do have to put in the I had to put in the passcode.
Yes.
Don't tell me the code, but did you have a 4 or a 6 digit passcode locking your iPhone at the time?
I don't know if it was a digit code or Face ID.
Well, if you have a Face ID, you have to have a
do it with your
digit code as well, right?
I guess so.
Okay. Did you open your phone with your Face ID or a multi-digit code?
I have no recollection of answering the phone or calling anybody back.
You also have to navigate, once the phone is unlocked, you have to navigate to the phone app, correct?
I don't know necessarily if you unlocked it with your face, if it would be right there. I have never thought about it.
Once you unlock that phone app, you have to manipulate the phone on the screen with your finger in order to make a call, correct?
You would have to hit at least one button, I guess.
At least one, right?
Yes.
So that's 3 or 4 interactions with the phone that have to.
All right, I think we get the gist of this. So let's go back. Let's now go over to, let me remove this. I want to go to Jennifer what was her name? McCabe? Jennifer McCabe? Is that right?
Yeah.
Let's go to Jennifer McCabe. Explaining her butt dials. These are the people we're supposed to believe. Like, are you freaking kidding me?
And learn.
Ms. McCabe, we've talked in some detail about your calls with John O'Keefe on the morning of January 29th. You recall that conversation?
Again, the reason I'm playing this is because the idiots at Court TV want you to believe that there was no evidence presented at court from the other cell phone data from the people in the house and what was going on. There was a plethora of evidence shown in trial about cell phone data from all those people, those liars in the house, and what they were doing. And this is what they were doing.
I want to focus
So
your
what the fuck is wrong with Court TV that they don't know this?
attention on or about or at or about 12:14 a.m., moving up to about 12:50 a.m. You have that time in mind?
Yes.
You've seen the cell right extraction from John O'Keefe's phone, which Mr. Lally showed you the other day, correct?
Correct.
And you went through the series of phone calls that were made and that appear on his extraction report, correct?
Correct.
I just want to run through those time-wise very quickly, just to orient you, if I can, and then I'll ask you some specific questions about it. There was a call at 12:14 a.m., correct?
Correct.
That was a call that you indicated was answered. You had a conversation with Mr. O'Keefe.
Correct.
It was a call at 12:18 and 47 seconds. That call also was answered by you. John O'Keefe made that phone call, correct?
Correct.
Then there's the 12:29 and 44 second call that you indicated was not answered.
Correct.
And that was a call to you, from you to him.
Correct.
There was a 12:41 call from you to John O'Keefe, correct? That was
correct.
There was a 12:41 and 54 second call from you to him. Is that right?
Correct.
There was a 12:43 and 19 second call from you to him.
Correct.
12:46 a.m. and 16 seconds from you to him.
Correct.
12:47 and 52 seconds from you to him.
Correct.
And 12:50 and 37 seconds from you to him, correct?
Correct.
You saw in his extraction report that all of those calls after 12:18 were missed calls, correct?
In his report that you showed me?
Correct. In other words, the only two calls that were answered were the 12:14 and 12:18. Everything else was a missed call.
I believe so. I would have to refer to it again because I've seen so many reports.
And Ms. McCabe, according to the extraction reports that you've seen this morning, comparing yours to his, every single one of those calls was deleted off your phone, correct? According to the reports.
According to that report, yes.
Let me ask you another question. Have you ever misplaced your phone?
Yes.
In life? Everybody
all the
does,
time.
right?
Yes.
What's one of the first things you do if you're with your daughter or your husband or a friend and you're in your house and you misplace your phone? What do you do?
Oh, I'll ask them to call my phone.
Even over and over and over, right?
Oh boy.
Correct.
Could be as many as 5, 6, 7 times.
That's why you get
Usually I hear it the first or second time.
You're looking for a buzz or a ring, isn't that right?
Correct.
And you might do that if you're searching for a missing phone, correct?
Correct.
With regard to the calls that were deleted from your phone, you were asked about this under oath at another proceeding, weren't you?
Correct.
And you claimed at another proceeding that you had an explanation for all these missed calls, starting at 12:29, 12:41, 12:41, 12:43, 12:46, 12:47, 12:50. You have an explanation for that, right?
Can I see the report?
I'm asking you about your prior testimony.
And I'm asking
about these calls.
Yes, I'm asking, can I see it, please?
I need to remember what I said.
At your other proceeding.
Because I don't remember what lie I came up with back then.
At this other proceeding, which you were under oath.
Yes.
Right? You explained that these calls were what? These missed calls, incessant missed calls. What were they? You used a word. Matter of fact, 2 words.
I believe I used the word butt dials.
Oh,
you claimed
Jesus.
that every one of these calls was a butt dial. Is that right?
Yes.
So according to you, you literally butt dialed John O'Keefe's phone 6 times in the span of 19 minutes. Is that right?
I don't remember making any of those calls. So my assumption is I put my phone in my back pocket and that was it.
When you dial someone by mistake, hit a button, set your phone down, the phone has to be open. You'll hear that, right?
Correct.
Can't be locked, because it takes several iterations of movement to get a phone open. Face ID or password, right?
Correct.
So when you hit the button by mistake, walk away, that's a butt dial. People call butt dials. What happens with the call?
I assume it goes to voicemail.
Good assumption, because that's exactly what it does, isn't it? You've had a phone for a lot of years, right?
Yes.
It rings and rings and rings until it goes to voicemail.
Correct.
So in order to hang up that butt dial, you have to interact with that phone yet again, don't you?
Yes.
So if you had 6 butt dials, I think it's 7 butt dials.
She has a very talented ass. Her ass just interacts with that phone all night long.
Once, butt dial, John. You then have to interact with it every single time to turn off that phone ringer so it doesn't go to voicemail.
I suppose.
Which makes 14 interfaces with that phone over the course of 19 minutes.
She's just doing
Is that right?
calisthenics with her phone in her back pocket.
I mean, I guess I don't have it all right in front of me, but there were also text messages I was sending. So again, maybe I said,
That's even
shoot,
worse.
I called them,
Why?
and then I turned it.
What? So now she's looking at the phone, sending text messages while she's butt
Butt
dialing.
dialing,
John
yeah.
O'Keefe?
Like, that's
What?
arguably worse.
I just want to point out, though, that like Court TV is so screwed. This Court TV thing that I showed you was just a recent video. It was posted today about evidence that wasn't presented at trial. And it's like, here's all this evidence they said wasn't presented at trial. Like, Vinny, what are you doing? Why are you making panel? Maybe they have nothing to discuss. I don't know. But why would you say that there was no evidence from all these liars' phones at trial? Yes, there was. And it was all really bad for them. This is some of the worst testimony I've ever seen in my whole damn life. Ever. These people are liars. All of them. And people are like, oh, it would be so crazy to have all these people be liars. Well, is it though? I mean, I admit this is a crazy case, but I don't think that it's hard to believe at all that all of these people are lying. They're all lying. It's very clear that they are lying.
I think we found our new coven outside of Florida.
God, it's the Massachusetts, the original coven. So bring back the witch trials. Taz, thanks for the 5. I've been a member while you're on vacation. Oh, I already read that one, but you got a double read. Palmyra Productions, thanks for the 10. Oh yeah, since we're only an hour and a half away, I sent 2 researchers up during verdict watch Friday, Saturday, Sunday, and Monday. Got a bunch of juicy stuff. Oh, cool. Duncan, Idaho says, every time I upgrade my phone after a suspicious unaliving, I shred and dispose of my SIM card at my nearest military base dumpster. No big deal. Yeah, I mean, that testimony alone, Higgins' testimony about the military base, that clinched it for me. These people are hiding some seriously bad shit. And there's no explanation for why they all destroyed their phones. Kim Dodds, thanks for the 5. I'm glad you're back. I've been following this Legal Vices. This is for a few breadsticks. Always enjoy your commentary and view of things. Well, thank you very much. I was trying to get the droid to make noise, but it must have turned itself off. It does that. It power saves. Duncan, Idaho says he accidentally click-dialed Brian Albert during an intimate moment with his wife. His phone was right up in there, as is normal.
That didn't say click-dialed.
Did it say dick-dialed? When I read click-dialed, I ruined the joke. Tank Rat, thanks for the 5. Cuck TV, a large company that needs to skew the truth to fit their bottom line. Dollars. Yeah. Tank Rat, thanks to the 5. I've never met a woman who didn't have a password on her phone. I actually don't think you can disable them anymore. I could be wrong.
You can remove them, but it is highly discouraged because the encryption for iPhone specifically is tied to having a password on your phone. And if you don't have one, then everything is stored in clear text, and that is bad.
Right. By the way, my iPhone, I'm going to need your help fixing it later. It stopped recognizing my face.
Oh,
Now
okay.
I have to like log in with my Apple ID every time I want it. It's really horrible.
Okay. Yeah, we can do that.
I don't know what's going on. I tried to redo it and it just won't read my face anymore. I think maybe Apple's having a problem. So I don't know. All right, Larry's on his way. He is covering the whatchamacallit, the Rust trial. You know, I have something to say about the Rust trial too. I was listening to the hearing this morning. They were talking about what's going to be which witnesses are going to be allowed, etc. And as much as I hate Alec Baldwin, and I don't like this man, he's unlikable. He's just not very likable to me. I don't want that to color my opinion of this, trial and whether I think it's fair or not. And I don't know. After watching what I watched of the other one, it seems to me that the responsibility for this is squarely on the people who've already been convicted. As an actor, I get that they're going after him because he's a producer too, and so he should be aware of these things and whatever. And while I think that that's somewhat true, he was also an actor, and when you're in that actor position, you're relying on the people you hired to do their jobs properly, and the person in charge was the props master, who completely failed at her job and allowed live rounds to be in that gun. How is he supposed to know that? I just don't know if that is negligent manslaughter or whatever it is they're going for.
So my counter to that would be, actors don't hire people to do things on sets. Producers hire people to do things on sets.
Mm-hmm.
So that's...
It's going to be interesting testimony.
Yeah.
They're going to allow in the people who are saying that they saw a problem with her and he should have seen one too. And speaking of the Rust trial, buckle up everybody, because hashtag it's the law. Larry, how are you?
Hey, I'm doing good. How are you all?
Good. Thanks for dropping by.
Got a new haircut, man. You're looking good.
Oh, thanks. Yeah, no, this is I'm growing my hair out and this is gelled up, so.
It does look good. I like it. So you're coming to us from New Mexico. You and Chandler are going to be covering this Rust trial. Chandler's in the courtroom. You're in the hotel room. You're doing all of this live all day long, every day. Good for you. Thanks for taking a break to come over here and give me your reaction to the Karen Reed news.
Yeah.
We just went through the new motion and the affidavit, and just take it away, Larry. What's your reaction to this?
Holy freaking shitballs is my initial reaction, to be completely honest. Okay, so here's the thing. The fact I've been screaming this from the moment they first came back. We can't decide. We can't achieve unanimity on Friday. What was it? June. The first time we heard from them, June 28th.
That's even before the Allen charge got read.
Correct. Okay. So they came back on June 28th around 10:30 in the morning saying we can't decide. And this is after on June 25th, I think it was a Tuesday, also at like around 10 in the morning, when they said, we don't understand your instructions. And Allen asked for clarification. The jury, for the first time in American jurisprudence that I'm aware of, at least that's been publicly televised and publicized, we have had a judge modify jury instructions in the middle of deliberations. This is like 4 or 5 hours into their deliberations. From the text messages that you guys have already went over, I presume, where one of the jurors admits that the paper was confusing, talking about the instructions were confusing, meaning the jury instructions. So your viewers already know, I imagine. That even added another layer of confusion, because now not only do they receive the initial instructions that are probably about this thick when they were going through them, now there's also a modification that they need to basically start over. So that's adding another layer of confusion. So let's get back to the 28th. So June 28th, they come out and say, Your Honor, we cannot achieve unanimity. We're unable to agree, all 12 of us. At that moment, okay, again, this is from my personal experience, from seeing other trials, I have had 1 out of 50. This is how rare they are. I've had one case in my entire career that is my own personal case with my own client who paid me, and I represented him all the way from jury selection to closing argument. The jury hung. And the first thing the judge did was bring all the jurors back. And again, I understand it's a different jurisdiction. It's not Massachusetts, even though I'm telling you, I don't think it's limited just to Kentucky. It would be bonkers to say that this is just a jurisdictional thing. The judge brought them in and they said, okay, so I understand you guys are split. Or excuse me, that you guys can't decide. And they said, yes. And then he asked, well, how are you split? What's your split? And right before they came in, the judge, the prosecutor, and I, the three of us, we talked, and he was like, well, if it's like 5-1, I'm going to Allen charge them, which is the same as the Hernandez. Hernandez, Allen, it's synonyms. It's different. One is a Supreme Court case. One is specific to Massachusetts.
Mm-hmm.
And Kentucky uses Allen. We don't have a specific one. We just use the 1896 case or whatever. And he said, well, if they're like 5-1, maybe 4-2, I'll Allen charge them. That was kind of like the gist of the conversation, if I remember correctly. And they came out and the judge asked, well, how are you split? And the jury kind of looked at him and said, well, 3-3. 3 guilty, 3 not guilty.
That's a little different.
Well, number one, it is. And number two, the judge kind of looked at them and was like, well, I'm not going to Allen charge them. I'm not going to give them the Hernandez equivalent. I'm simply going to let you guys go because it seems like you guys are a little too far apart. He never sent them back even one time to redeliberate. He said, to me, that's enough. I don't remember how long they deliberated for, unfortunately. I want to say at least a couple hours, but please don't quote me.
Is that up to the judge's discretion?
Yes, 100%. That's within the court's purview to decide what to do with the jurors. Now, having all of this knowledge in my head, when the jury came back on June 28th in the morning, my first thought, and I think I was screaming this at the screen when Judge Bev didn't do this.
You were. I was trying to find it. I was trying to find it because you got so mad. You were like, do your job. Like, why aren't you polling the jury? And I was thinking the same thing. We were all thinking the same thing. Like, what do you mean you're just going to we're just going to go away now and like it never happened? We need to know, where are they at?
And on which charges? Because you have count 1, count 2, count 3. You know, if you remember the verdict form, it was not guilty, guilty on murder second, involuntary manslaughter, and then Ted Daniels just posted that Proctor has been suspended without pay.
Is that true? Well, yeah, his hearing was today. Man, if that's true, I hope that's true.
Yep, he just tweeted that.
I see it. Breaking: Massachusetts State Trooper Michael Proctor has been suspended without pay during duty status hearing today. Does that mean fired? Does that mean just fired completely?
Pending investigation, I would imagine.
Yeah. Well, that was the worst thing that could have happened to him, so that's good, I guess. Yeah, here's an article from 25 News. Hold on, let's see. We'll put it up here. Share screen. Trooper Michael Proctor, lead investigator in Karen Reed case, suspended without pay. Massachusetts State Police Board recommended that Trooper Michael Proctor, the disgraced lead investigator in the Karen Reed murder case, be suspended without pay amid an ongoing internal affairs investigation into his behavior following the death of Boston police. Yeah, well, good. Good. The texts were beyond unprofessional, by the way. They were an insult to the badge. They are an insult to any person suffering under that badge. It is police tyranny that should never be tolerated. This man should not only lose his job, lose his badge, but he should be prosecuted because he violated her constitutional rights. Yeah.
That link in the private chat, if you don't mind.
Of course.
Thank you.
Of course.
Continue. Sorry, Megan.
But I mean, I just think that he should be prosecuted for violating her constitutional rights. I think when you're a state actor and you violate your oath to the Constitution, I think that should actually come with the death penalty if you're found guilty of it. I do. I don't even like the death penalty, but I think the only people who ought to be subject to it are people who have sworn an oath to uphold your constitutional rights and then they violate that. I think that's the one thing in this country that should receive a death penalty. And the reason why they keep doing it, the reason why they get away with it is because there is no not even a prosecution. We don't even prosecute these people when they violate your constitutional rights to liberty. In fact, in most cases, they get promoted. Look at all the CPS agents who have violated the rights of parents, the constitutional rights of parents. They usually just get promoted. It's crazy.
Yeah.
All right. Anyway, sorry. Go back. You were saying.
No, please. This is huge. Worth interrupting.
It is big. Look at this picture of him, by the way. It looks like he has a big divot in his head. And it's just because of the way the light is hitting it. But
Right.
it looks like somebody hit him in the head with an axe. Did you see this? This is bizarre.
Let's see that.
God, I hate this guy.
Yeah.
This guy has a rat face, man.
I've been doing a series on him on my channel. I've been breaking up his testimony. We're 8 episodes in, and there's probably going to be at least 3 remaining. I'll do them after Baldwin.
I think I found where you lose your shit on the judge. Let's see if I can make it stop spinning. That would be nice. Ugh, it's just gonna spin.
Damn it. I'm sorry, you guys. I'm livid. I'm absolutely livid. Just
Why is it spinning? Stop spinning.
incompetent. Just completely incompetent. The whole point of an Allen charge, before you Allen charge a jury, which is, like I said, that is when you
God, what's going on with my YouTube?
issue them a specific instruction to encourage those in the minority to reconsider their position. You don't just willy-nilly send them back.
It's true.
There's a specific way of doing it. There's a rule of law from 100. You like to quote John Adams so
I love this part. You like to quote John Adams so much.
This law has been around for 130 years, woman. 130.
It's like losing your mind. This was fun to watch.
It's funny you got the Kiss shirt on in that video, and you got your Iron Maiden on now.
Yeah, right. I was just thinking about that. Like,
I always like dual Larrys. Dueling Larrys is always fun. But yeah, you were like screaming at the screen. Do your freaking job, lady! Like this is terrible. It's terrible what she did. So now, all right,
Yeah.
Larry, what do you think is the possibilities? I'm concerned about jury intimidation at this point.
yes.
If we have these 3 jurors who are saying that they were all unanimous and there was no consideration of murder too, but we also know, according to those text messages, that certain people felt intimidated by the Allens being in the courtroom that day. What are the chances that these people are actually going to come forward and say, yeah, we were unanimous on that? And what if some of them may just not want to be involved in this at all and just want to be like, I never said that.
Okay, so let me just take a step back, finish my first thought.
Yeah.
Remember that the hung jury, she at least after the first time, okay, even if we give her a pass on the first one, even if we decide to give Judge Bev a pass on the second one, the third time they came back, we can't decide. At that point, it was absolutely, in my mind, if I was the judge, it is absolutely mandatory to inquire. So what is your split? Where you guys can't decide? Oh, Your Honor, charges 1 and 3, we are all unanimous, not guilty. But on charge number 2, we're split 6-6, 8-4, 9-3.
Right.
I have 3 different accounts. So I don't know which one is correct. That would immediately solve 2 out of the 3 charges for the government, and then they would not be able to retry. Res judicata, double jeopardy, etc., would apply, and they can only retry on the second charge. They wouldn't be able to retry on all 3. By virtue of Judge Bev intentionally, I'm convinced.
I'm
at this
sure it
point
was
that she's in
intentional,
on
too.
this.
I
She
know
does
it was
not want
intentional, too.
information. She wants it as vague as possible, as open-ended as possible, so
Yeah.
that we can start all
So
over
the
again.
state can do whatever it wants.
Exactly.
She's absolutely did this on purpose. She absolutely did. This was intentional, that she did not poll the jury because she did not want that to be out there if she was acquitted on one or more of the charges. And I think that it's disgusting, and she ought to
Yeah.
be kicked off the bench.
I agree. 100% agree.
'Cause
She's
there's no
a
other
danger
reason.
to the people.
Oh, absolutely. A total danger. This is judicial tyranny. It's sick that we now have to go back and try to fix this issue that she should have just handled immediately right then.
Yes.
So the one question that you were alluding to, Megan, is can the judge, when they release the jury, say you are released from your subpoenaed obligation as the jury, can they re-subpoena you in order to perform this evidentiary hearing that's being requested by the defense?
Yes, 100%. Case in point, January, Alec Murdaugh, Becky Hill. They already did that earlier this year.
Right. Exactly.
I would hate to put the jurors through. So now to answer your second question, Megan, I would hate to put the jurors through like a ringer again, like they did with the Becky Hill situation. I mean, that one was way more sensitive. You had a court clerk injecting herself into the jury process. She was literally communicating with the jury before deliberations, after they're sworn in, which again is a huge no-no. In this case, I think maybe getting a couple of sworn affidavits from sitting jurors may be sufficient, because so far what we have is we have at least 3 jurors, like you said, A, B, and C. 1 contacted Jackson, 2 contacted Yannetti. And if we can get, because right now we have affidavits of Jackson and Yannetti stating these people came forward and this is what they said. So it's still hearsay, but it is a sworn affidavit, and those are never taken lightly by a court. Even though they're hearsay, at the end of the day. But it's a sworn affidavit from, you're putting your bar license on the line if you're really messing around with it. So I believe 100% everything that they wrote, Jackson and Yannetti. But now, taking it a step further, if Judge Bev is going to be like, well, this is not enough for me, and if these jurors are going to be a lot more open and inclined to come forward, like you said, and there's always the danger, having that mafia boss, which I can't believe.
Oh my God! If I were on that jury, I'd move out of Massachusetts. I'd get the hell out of Massachusetts.
Did you see the title of their latest paper? Mass Exodus. Everybody's leaving the state. MASS period.
They ought to leave the state. And if I was on that jury, I'd be on the first bus out. Like I'm out. I'm out of here. I'm getting out of this jurisdiction, because there is no way that those people aren't going to be doxxed. First of all, they will be. Those police officers had their faces. They were sitting there staring at them that entire time. It's a small town, right? Camden, area is a small town. I guarantee you that they're going to be identified and they're going to be harassed. I guarantee it.
That's why they're so afraid. And they're deciding now. Apparently there's a group chat. I don't know how many of the jurors are in this group chat, if it's all of them, if it's some of them. I think it was the Boston Herald. Somebody in the chat wrote. I'm pretty sure it was. Don't quote me on this, though. I just saw the headline briefly. And
it's in the affidavit because intermediary B was in the Zoom meeting that was being discussed and relaying that information to the informant.
I bet somebody recorded that Zoom meeting. How much you want to bet? Carrie B says, LOL, I left. I moved from Massachusetts to North Carolina. It's terrible. We're running out of places to live in this country. By the way, we're running out of states where this kind of shit is not happening. And that's really unfortunate. That's what this whole show is about, is judicial corruption in government. I was just in Georgia. We were in Savannah for a couple of days before we went to Disney World. And the thing I thought of as soon as we crossed the border into Georgia was, oh my God, this place with the corruption and the judges. We got the one judge with the ex parte communication, putting lawyers in jail. And then I got 3 or 4 families in Georgia suffering under this medical kidnapping bullshit, in Fulton County, and then and then Jacksonville, Florida, same thing. Like, no matter where you go in this country, I can give you examples of horrific tyranny that's happening on a level that should not be happening, and most of it is happening in courtrooms. There's a serious problem with the courtrooms of America and what's going on there. It's good for LawTube, because we're never going to run out of shit to talk about, are we, Larry? But
no. Material for days.
Material for days. This case is unbelievable. This Karen Reed case is just when you think it couldn't get weirder or worse, it does. All right. So what do you think we're going to hear from the prosecution in response to this?
Jurors are a sanctified entity that should never be reinvestigated or re-asked in any way, shape, form, or capacity. Their decision should be honored. The decision of the court should be honored. We're moving forward on all 3 charges to see what a new jury says. If the court is inclined to poll these new jurors in the new case, they're more than welcome to, but the train has passed. The train has left the station. The ship has sailed the harbor. That's what they're going to say.
Oh,
that would be my argument if I'm a sleazy, corrupt prosecutor.
I think in order to regain some public trust, they need to just be like, oh, if that's the case, then yeah, we need to dismiss them and let's find out. Because my God, when you're a prosecutor, you are supposed to be in the pursuit of the truth, not in the pursuit of just nailing this one person.
Why do they care? Why do they care about public perception? They haven't cared up until now. Why should they suddenly change their tune and suddenly start caring? They've been under
the entire country thinks that the Massachusetts prosecutors are corrupt as fuck.
I don't think they care. That's the scary part. They're actually proud of it.
They're not voting for me, so why do I care?
Exactly. Like, I'm sorry, but like, God. I see like where your heart is and I'm with you, but
bad.
The reality is they just don't care.
No, they don't care. And then we have on the other hand, I don't know if you heard about this, Larry, but I was actually going to talk about this today, but I'm running out of time. So maybe we'll do it tomorrow. But Steve Gosney just got a new job at the prosecutor's office in Miami-Dade, and he's the ethics. He is going to be training prosecutors in ethics. That's his new job. And it's interesting because they wanted a defense perspective there. They wanted a defense attorney to show them where they're going wrong with Brady violations, et cetera, because they're interested in cleaning up the problems in the prosecutor's office in Miami-Dade. Well, right after he got hired, the Miami Herald has this hack journalist who digs up Steve Gosney's new racy novel that he wrote about death penalty. It's called Death Penalty Desires.
I was waiting for that.
Oh, yeah. And it says that the prosecutor's new hire wrote a violent, misogynistic S&M novel and puts it out there as if, by the way, I read the thing on the way back from Florida when I heard that this happened. I read the article this woman wrote. And it is so outrageous to take a fiction novel and try to say that it somehow says something about the person who wrote it, as if, first of all, he's a defense attorney, right? He's seen a lot of horrible shit. There's a lot of horrible shit going around in Steve Gosney's mind, like a whole bunch of horrible stories that he can't talk about. So what does he do? He writes a fiction novel where he can put some of this stuff in there, some of this horrible shit that he's seen prosecutors do. And most of it is based on true stories. And they're basically saying, oh, this came out of Steve Gosney's disgusting brain. It's like, no, actually, the things that he's writing about were done by prosecutors that he worked with, including eating popcorn while watching videos of little girls being ARPed. Yeah, on videos. Yeah, in cases. And they're claiming that Steve Gosney made that up. Like that was something that came out of his warped mind. And it's like, no. That was something that actually happened. That prosecutors he watched do this. And so now you've got the Miami Herald going after the one guy who's actually interested in ethics and cleaning up prosecutorial misconduct. And the book itself is not about sex. It's not, that's just like thrown in on the side for, the 50 Shades of Grey folks. What the book is actually about is about prosecutorial misconduct and judicial tyranny. That's what it's about. And it's about the problems that with the death penalty and how it can go so wrong. And this woman and her commie co-author, who's literally a commie. I'm not just calling her a commie. She's actually an avowed socialist. When they went and dug up the most salacious parts they could find to accuse him of being a misogynist, just because the bad guys in his book are misogynist. It's like, this makes no freaking sense. So when you finally have a guy who's willing to do something about this, who wants to do something about prosecutorial misconduct, they're going to try and destroy him based on a fiction novel. I mean, this is so dumb. So I'm going to eventually, we'll read through that this week, and I'll give you my take on his book.
Hopefully not the book, I hope, right? Just the article. Just the article.
Well, and then look at this. Steve even wrote 2 different versions. He wrote one with the sex and one without, so that you could actually choose which one you wanted to read. So
50 Shades of Ghazni, somebody wrote.
Yeah, 50 Shades of Ghazni. It's really not that big a deal. Like, it's really not. You know, I mean, some of the sex stuff is weird, but other than that, it's really a side thing anyway. The actual point of the book is about the misconduct and the problem of ethics in prosecutorial offices across this nation. So anyway, a couple of people have read the book on YouTube and Rumble, I think. So if you wanted to listen to it read to you live, you can read that. Slidey Pie says, I'm reading that book on my channel. So yeah, I mean, it's silly. It's silliness. So anyway,
by the way, you have Flux and Nicholas Stero in your chat. So good for you.
Hey, Flux. Hey, Nicholas. I didn't see you there, Nicholas. Where did he go?
I missed him. It was a couple minutes ago.
Oh, excellent. Well, I missed him. It's going to take me a while to get back in the swing of things after being on vacation for so long. So Larry, what do you got coming up? What's your schedule?
Game plan for Rust?
What's your game plan for Rust?
So we're going to stream every day. There's going to be 3 videos premiering on our channel. Video number 1 is morning of the trial. Video number 2 is going to be the afternoon of the trial. And video number 3 is going to be a summary. Depending on the day, most days I'm going to be in the courtroom watching the jury taking notes. We actually just ordered a new laptop just so that Chandler's laptop just dies too quickly. Oh, no. So we're going to be taking notes on a computer, and then when that dies, we'll take hand notes and tweet them after. So primarily,
you get like a portable charger for those things.
Well, for a laptop, I don't know. It's the new Apple, the 2024 Apple Mac.
Okay. Yeah, so the new MacBooks with the M processors should run really efficient, and it should last you. But you can get USB Type-C power bricks to be able to charge them for additional juice.
Really?
Yep.
Mm-hmm. That's what I figured. The portable chargers, yeah.
I'm okay. I've learned the Johnny Depp trial. You can take hand notes and that'd be sufficient. You know what I mean?
Yeah. You can. It's just easier when you have when you can type, because I can type faster than I can write.
Truth.
That's for sure. But yeah, so you guys, you're going to be in the courtroom. Are you headed to the courtroom?
So Chandler's been in the courtroom today, and I've been streaming. So we decided to kind of pull a switcheroo since the jury's not there. I said, Chandler, all you, baby, go have fun and bring us the juice. Tomorrow, we received a media advisory from the New Mexico courts that tomorrow there will be no live stream of court TV because jury selection. Apparently, New Mexico has a specific
law. They're not going to let us watch.
That says when there is when the jurors are in the room, cameras are not permitted to be in the room. That's like an official New Mexico thing. So we're not going to have.
Wait a minute, ever?
Apparently, that's
how
the way
are they
going to
carry the trial when the jury's in the
for
room?
selection?
For jury selection, just for jury selection.
All right. So what did you think about the ruling today about the witnesses that the prosecution wanted to bring in? What did you think about that?
So the one witness that I thought was a complete sham was the guy who was apparently a grip like 30 years ago and was going to testify about how to be a producer. And I'm like, okay, come on, that's an easy one. But there are some others that I'm like, I was on the fence for the longest time because like both parties really made some good arguments. And I'm not a fence sitter. I will jump to one side or the other if I believe one side or the other, but they both like really made some good arguments. Like the statements by the victim moments before she died and like the video, I think that should all come in. I don't understand why. I mean, look, let me rephrase. I understand why the defense is trying to exclude it because it's highly prejudicial to their case. It's prejudicial to Alec Baldwin. It's prejudicial to their client in every capacity. But to try and exclude it just seems, I mean, I probably would have done the same thing. That's the problem. I can't really look at him and be like, why on earth would you do this? So them trying to exclude her statements is all nice, But I don't think, and I think they lost on those. I don't remember what the ruling was on that particular one. But
Well, they lost on all of them. I think the judge said, "I'm going to let him in, but it's going to have to be relevant. So we'll make those decisions as we go about what the testimony
yes, that's why.
is."
That's because I was like, I don't remember
And
an
I thought
exact
that
ruling
was
on it.
good. I thought that was good because I also thought, I'm like, if I were the judge, I would allow it, but it would be very specific about what you could ask. It would have to be about what they personally witnessed on that set versus what they witnessed in other places. If you're going to bring up the other sets, it has to be in relation to what happened on this set, on the Rust set. Was the grip, was he somebody who was on the Rust set though?
No.
Okay, so that one I wouldn't have let in. I don't know if she let him in or not. It felt like
only
she did.
to read the bulletin. He's literally, all he could do is read stuff that is in existence. He cannot offer, he's not going to be entered in as an expert witness. He cannot offer his own personal opinion as to this is what should have been done if I were in Alec Baldwin's position. That sort of thing.
So the grip was what the prosecution wanted to bring him in to talk about how Alec Baldwin, the producer of Rust, should have had knowledge and been providing a safe environment for everyone on the set. And this grip is supposedly has written the safety bulletins for numerous sets, and they wanted to bring him in for that piece. And they're saying, well, because he sat in with producers, he can't be an expert on producers. But they weren't saying that he was a producer. They were saying that he was a policy advisor for the safety bulletins, and they wanted him to be brought in for that.
Well, it's going to be pretty interesting. So your coverage is going to be pretty complete, it sounds like, Larry. And how long are you there for the duration?
For the whole trial. It should only be a couple of weeks. Pretrial motions today, like I said, jury selection tomorrow. Chandler and I are both going to be in the courtroom tomorrow, so there'll be no live stream because there's nothing to live stream. And Wednesday, Chandler is going to be live streaming, and I'm going to be in the courtroom.
Fantastic. Well,
Every
that
day.
sounds like fun. I can't wait to see it. And I haven't decided whether I'm definitely going to follow this trial. I don't know if I'm going to be doing much more than maybe an occasional recap on this channel. I'm going to
Alec Baldwin might be testifying, Megan. So you got to at least be there for that. At the very
I'll be
least.
there for that. If I don't like the man, but I want him to get a fair trial. And I have questions. I have questions about this, to tell you the truth. I don't know if you can put him on trial for being a producer when the act happened while he was in the actor role. I have a problem with that. Because you can't be doing both at the same time, I don't think. I mean, and it depends on what his role as the producer was. Like, was it strictly monetary? Like, did he have any decision making? I mean, this is all I guess it'll all come out and we'll find out, like, who actually did the hiring, etc. But I don't know. I don't particularly like Alec Baldwin. I just want him to get a fair trial, and I don't want him to be treated differently than anybody else who would be on trial for the same thing, just because he's an unlikable guy,
My biggest thing, sorry, Brad. My biggest thing about this trial is the following statement, because again, my brain doesn't work like a normal human. I've seen too much. I've done too much. I've been in too much stuff I have too much experience to look at the world from a normal, like, layperson's perspective. The way jurors, I can speak from experience, the way jurors look at cases, they look at cases from the simplest point possible. If it looks like he did not do XYZ, meaning follow proper gun safety rules, did not check the chamber, had the finger on the trigger, if they believe the Commonwealth or the state of New Mexico that the gun just doesn't fire on its own. And that is, again, common sense. No matter how you look at beyond a reasonable doubt, unfortunately, a lot of times jurors will decide a case based on common sense. And common sense here dictates people don't just randomly get shot and guns don't just randomly fire. That's it. So with those two things in mind, the jury's going to look at it from, again, I always fall back. Occam's razor, I probably said this phrase, Occam's razor is like my default over the last couple of weeks with the Karen Reed case and now this. if the jury sits there and they go, there's only one saving grace for Alec Baldwin. If Alec Baldwin takes the stand, testifies in his own defense, and they believe him that he had no idea what he was in possession of, despite the fact that he was kind of like, hurrying and rushing. He was like, I was entrusting, Hannah, I was entrusting everybody else. And, well, then they're going to let him off the hook. That is the only time that's going to happen. But if he does not testify, and if jurors go to the most obvious answer possible, which is he did it, he's going to get convicted. That's just, again, Occam's razor. I can't, there's no spin you can put on it.
That's what I was going to lean into that. I was going to say, even Team America World Police said you've got the best dang actor going up on stand, and you got to watch out for the Amber Heard like moments to see whether or not he's actually giving the story that's truthful, or is he acting, and trying to see if you can. And
he's
decipher
a much
between
better.
The two.
He's a
he
much
is a much better actor than Amber.
Than Amber Heard. So I mean, I'd probably put him on the stand if I were his attorney, because I think Alec Baldwin can portray whatever it is he needs to portray. So that would be something that I probably would do. Although it's risky. It's always risky. So we'll see what happens. Larry, thank you so much for coming by. I appreciate it. I'm going to get to the super chats and then I'm out of here.
No problem.
But thank you so much, and I hope to talk to you again soon.
All right. I'll see you guys. Thanks for having me.
Larry.
Bye. All right. We got, who do we have here? We've got Zoo Renard. Auntie Bev did not want to give Karen her not guilty verdict. What a vile woman. I agree with that. I think that she did not want that out there. It pisses me off. Sunshine says, what is the armorer for if you want the actors to take responsibility for checking the firearms they don't know anything about? I kind of agree with that as well. Duncan Idaho, thanks for the 5. The McAlberts are all nudists, interacting with their phones in the unlikeliest of ways at all times of the day, with all manner of appendages. That is what they want us to believe. Time Lord Cloud, thanks for the 5. Proctor should be charged with treason. Jay Water Road Less Wolf, thanks for the 20. Megan, I would modify that statement from just those who sworn the oath to the Constitution to those who swore an oath to the Constitution and are serving in the interests of government facilities currently. Yeah,
that's implied by swearing the oath,
right? And the only people who do that are usually government officials, right?
And
Duncan Idaho,
military.
thanks for the 5. Good incentive for Massachusetts residents to just live stream their dash cams whenever they're pulled over, unless you trust Proctor's the system backing them. Yeah, if you have a dash cam. I mean, I don't have one of those. Mag in Florida, thanks for the 5. Judge Bev de Thomasis. Yeah, that's funny. Paul Croak, thanks for the 5. What did Jackson ask to be put in the amended jury instruction at the top? He asked, what he asked for was that there was a second box for not guilty, because there was only a box for guilty, and they needed one in the other charges to say not guilty. And it was unbelievable that it was like that. Chris Jenner, thanks for the 2. Why is Alec responsible for being handed a loaded gun? Well, I guess we're going to find out what the rules were, what is on set, what are you supposed to do? I guess you're supposed to, as an actor being handed a weapon, you're supposed to check the rounds. I just don't understand why live rounds are on movie sets in the first place. I think that should be an absolute no, never. Like you can never have a live round on a movie set. And I don't understand why it happens. And it happens because people get killed on movie sets all the time. And it's disgusting, and it shouldn't happen. But anyway, it's going to be an interesting trial. Thanks for tuning in today, guys. Brad, thanks for being here. And I don't know what my schedule is going to be like. We will definitely do Tuesday with Tug tomorrow night. We will get back on that schedule for sure. My streaming during the summer is going to be kind of interesting. I'm probably going to move to earlier in the morning, maybe from 9 to 11, I'm thinking, because I need to facilitate the fun with the kids during the day when the sun is up. So it's going to be a little difficult for me going forward until school begins again in September. So my schedule is going to be pretty off, but I think you guys will catch up. I will, if you're following me on Locals, you can do that for free, meganfox.locals.com, where you will always get notifications about when I'm going live, because YouTube is asshole. And sometimes YouTube doesn't tell you when I'm going live. So make sure that you check the locals for that. All right, Brad. Everybody go subscribe to IT Goatee Brad on YouTube. He's got his YouTube channel as well. He's doing some fun Q&As over there about all your IT questions. So make sure you go and do that. And I'll see you again tomorrow. Bye, guys.
See you.
I was lost, my world is near its end. I almost felt my head is full of million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with million voices. Oh, this road has many choices. Oh, in my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. No, I don't wanna say. No, I don't wanna say goodbye. This time I know my road is near its end. I almost felt my head is full of million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with million voices. Oh, this road has many choices. In my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. No, I don't wanna say. No, I don't wanna say goodbye. No, I don't wanna say goodbye.
So I take it that you've
Johnny's problem
seen
is he
Cameron
should have
John's
come
bedroom
storming
before.
in there with
Yeah.
a string of
Do you
garlic
recall what
and
he
some
went
holy
into
water.
Mr. Jepson's
A cross,
first
a crucifix
bedroom?
one.
May the
Do you
power of
recall,
Christ
or no,
compel you.
No, I don't.
You realized his house was infested with succubuses.
There's just you're looking of what it, yes. Do you
Suck
recall
you
what that was
loaders.
there when you arrived in the afternoon? I don't remember seeing it now. So while she
No wonder he said drown her before you burn her.
Oh my god.
You-
Your next witness?
Now I know
Witness
why
for
you wanted to
knowledge
drown
of
her.
laces, and that is
Witness
also
lives in
by
Romania.
video.
Is that correct?
That begins with Miss